essentially, after having another conversation with zoning yesterday on my specific issue, based on the wording of the resolution and the passing of that resolution, there's no guarantee that this board or future boards will come back and make an amendment or changes to allow easements to private lanes or non-county highways, as well as the 150-foot frontage rule. Our specific situation is a 60-acre piece of ground that we're going to add one home to. I'm in a position where I'm being told I have to be put on this out. And my concerns are, instead of adding those provisions in today and saying, let's look at this and remove them potentially later, I'm in a position where I can't move forward on house builds and I'm ready to start now. And I'm also at the mercy of the housing market fluctuation up or down. So if I get told today or tomorrow that the resolution passes and I'm not allowed to move forward with my project, and that current house that I own loses value, that can potentially cost me a significant amount of money towards the building process on the home that I want to build today. So I would urge you to ask the county attorney, I don't know if he's here today or not, but ask whether or not those provisions can be added into this reading for Jenny and I that both have similar situations on what our projects are that we're wanting to be able to move forward with. And then as you convene through this process in the future, determine whether or not there needs to be changes to those. But just giving us the explanation of we can't do this now, we have
6 months, 10 months, whatever the case may be, and I don't feel that that's right for the county to just say, hey, you gotta wait while we figure this out. My preference would be that you figure out what the rules are before you put them in place.
Appreciate it, Shaq.
Thank you, Matt. Is there anybody else from the public who would like to speak today?
My name is Rich Ayers, 6876 Harding Street, Indianola. This is South Indianola. I would just like to say that I support the zoning ordinance the way it is. There are avenues that a developer can rezone the property to get more houses per acre or multiple acres. In terms of the easements,
Correct me if I'm wrong, but isn't there a board of adjustment in the county that, for instance, the lady that spoke yesterday, she could go before them showing that it was a hardship, not of her cause? The concern of 40-foot easements is a developer could sell the lots along the road, have an island in the middle, and just come in and arbitrarily put in 40-foot easements and not to scoot around a rural residential zoning. And the intent is to control the growth so that the utilities are maintained. Rural water can only handle so much expansion, and if we just have 3-acre parcels all over everywhere, we're going to box ourselves in corners. So I support the ordinance the way it's written.
Thank you very much. Anybody else from the public? Anybody online? Okay. With that, nobody else from the public? Okay, I'll make a motion to take the public hearing.
Second.
Roll call.
McIntyre.
Aye.
Snell. Peter.
Aye. Okay, so, I guess I'd just share some comments from my perspective, and I've heard from a couple of people over the last just couple of days. I think that the intent of what the Warren County Board of Supervisors is trying to do is in the betterment of Warren County in general. And what I see is some isolated issues with certain people that these are going to negatively affect for a while. And I don't like that. I don't like putting things into place that disrupt somebody's ability to move where they want or to, build a house where they want to. But we've been dealing with this. Crystal's been dealing with loose building standards for quite some time. I've been dealing with them. Mark's been dealing with them. And it's, from everything I can tell, what we're doing from an engineering perspective, from a zoning perspective, from a plant growth perspective, land use planning is critical to the growth of Warren County. This is critical. These are critical ordinances and standards that need to be put in place. And my position is that we put these in place with the understanding that there are potential, we have to accommodate our public to the best of our ability as time goes on. And these are not set in stone from the standpoint of being amended or a potential variance process. I've gotten feedback from the Board of Adjustment. They think that when we put these in, that they're going to see a ton of variance requests, and they're not looking forward to that. So that's a roadblock, or that's a thing we need to understand and work through. But those are my comments, and I guess if there's any other discussion from the board, otherwise, I'll make a motion when you're after your comments, if you have any.
I really don't have a lot of extra comment. I think it's very worthwhile that we have the public input here, because I've had several conversations since we even had the board meeting yesterday. And as a result of that, I felt as though I needed to double check and make sure I understood the potential impacts and the direction. And I guess to reconfirm what I thought we were doing, and that I did understand what we were doing. I've had that reconfirmed. And after following, this is not like this is just all of a sudden. This has been under a lot of scrutiny to get it to where we are today. There's been no less than 5 planning and zoning discussions on this issue, let alone the 2 that we had within as a joint board as well, plus the ones that we had in preparation for all this. And
They were online too, so.
Yeah, and so as a result, I know some people are just now understanding and starting to hear about it. So, it's like anything, when you get cold water put in your face, you have a little reaction. But once you have a chance to maybe think about it and understand a little bit better what we're trying to do, I feel like we're on the right direction here. I'm not sensing we need to move away from the direction that we're going at this point. I'm not, at this moment, feeling as though we need to make amendment to what has been proposed so far at this moment in time, especially because of, I think the way that the county attorney expressed it yesterday was very, very well put. When he said, remember that these ordinances were put in place way back in the 1980s. And he says, what we're trying to do is at least get them to be in sync with the plan that was put in place in 2002. So in other words, we're not at the end point yet. We're somewhere along that spectrum of getting to what will be an end point probably 10 to 12 months from now. So from that perspective, I'm comfortable with what has been discussed, because I know that a lot of eyes, a lot of conversations been held, a lot of very careful thought has been put into what we're doing so far. So I'm okay with where we are. I understand the easement question is a concern, but I think there's also ways to deal with some of those issues. And some things were brought to my attention following yesterday's concern, especially with Jenny's situation, she is not, she has options. And I don't know Matt's particular situation quite as well, but I think there are options available. We just have to figure out, they'll need to figure out what those are as we go forward. So I'm not uncomfortable with what's before us and what we are potentially going to adopt here at some point after the third reading.
Thank you.
Well, I am concerned about the max, because if Mac is one person who's going through this, Jenny's another, there must be others who might come forth who don't know yet, but then we'll figure out, and they're gonna be caught in that 10-month. I don't, like he's just explained, he's on a time crunch here. He wants to sell his house before the market tanks, and I get that. There's an urgency to what he wants to do. And we are the holdup. The government is the holdup, and it's his family's land. And I mean, he said it best, you know, government is telling him what to do and what not to do right now. And that, I want us to safeguard people, but not to hinder their progress. And I feel like we're right at that avenue right now, or that crossroads where this could hinder him from doing what he needs to do. So can we put a provision in this, just talking about the easements, and then, you know, along the way, after we've done this, figure out how we want to word that appropriately for the future? But my safeguard would be for those who are caught in this 150-foot frontage, and I understand why we're doing it for the subdivisions, but this is one person wanting to build a house on one piece of land. So is there a way, can we add something to this in these hearings when we go to approve?
Can they do a conditional approval with the definition of easements as the contract for that?
Sir, could you come forward and ask your questions so the public can hear?
I was just, so yesterday we had discussed the opportunity to approve the ordinances conditionally with the addition of the easement.
Right.
So I was asking Doug if that would be an opportunity today to approve it conditionally with the addition of the easement.
Okay. I think
Hold on a
It looks
second.
like they're discussing.
You're talking about, here's my concern with what Chris was saying, and I think what you're proposing is that, you know, in the past, we kind of looked at each project from from a perspective of using our old ordinances. So we would interpret those one way, and somebody else would interpret those another way, and then we'd end up, the decision would come to the Board of Supervisors, and then it would just be a kind of a decision on how the board felt at the time. And it wasn't really a decision based on what our process is, what our policies are, what our ordinances say. And so if you're asking for us to change this document and change our ordinances based on one situation, I would not be in favor of that. Because I think that's what gets us in trouble long-term and from a consistency perspective. Because, you know, I would be way more comfortable, and with my conversations with Mac, figuring out if there's a new, you know, policy that relates to our ordinance that makes our overall process more consistent. I'm in favor of that, and I think that's where this is going. But to say, you know, we're gonna take this out of our ordinance so we can let this one go, I just, you know, that kind of defeats the purpose of what we're trying to do. And I said from day one that we need to set the bar high, and that's what we're doing through this process. These ordinances increase restrictions, there's more process around plats of survey and how accesses work and how things are built and what angle the driveway's on and, you know, all the details. I mean, and the easement issue, you know, we've got, whatever we do today, I want to be able to go to our public tomorrow and say, this is our policy, and this is where we stand. And these are tough things to do, but someone's got to take a stand at some point to straighten this out. And I'm not saying Matt can't build his home. I know he's got an easement issue, no one can find an easement. I want to go down with Mac after this meeting and go to our recorder's office and figure out if there is an easement. I called the recorder, they weren't aware of the request. So let's, you know, there are things we need to do with Mac to just get started on this process. And so that's kind of how I see it. But, you know, if there's something we can take out of this, that we can say this applies to all people everywhere in Warren County all the time, I'm in favor of that. But I'm not in favor of taking something out of this that we can't consistently take to our public. That's just how I'm feeling about this right now. But, I mean, there's 3 supervisors, and I'm open to any kind of motion for this. But I think what Matt is asking for is to take out one of the critical elements of what we're trying to do. The 150-foot frontage is there for a major reason, to eliminate many problems we've had.
I agree with you completely.
Okay.
What I've learned since the easement issue was brought up yesterday, I've spoken with some of my colleagues at counties that have procedures to address this. So they don't allow easements in new splits and new development, but they do have procedures. They have permits or allow variances for easements for existing lots of record that would need that to have access. And I think that that would be a good approach to the issues that we're seeing with easements currently.
Okay. So can you develop a resolution that you think or develop what you would like to read as, because I'm not sure.
The ordinances have to be amended from what we've seen. I mean, just like you've done the strike and the add situation, you need to do that same thing.
So for what I was just discussing, the ordinances would remain the same as what they have been proposed to you, and the existing lots of record that do not have access would be allowed variances for easements if necessary.
And how long does that process take usually?
For a variance,
Mhm.
I would have to ask the staff.
Okay.
Lindsay or Miranda, do you know the approximate time frame that a variance?
That could happen. I'll know that, Doug, that has to go in front of the zoning commission. That change would have to go back in front of them.
Okay.
Yeah.
But if somebody is, what she's talking about, I think, if I'm understanding right, is this variance would be outside of this ordinance. It would be, the ordinance would stay the same.
It's just part of your process.
But then
These
you would like
would
have
be
that to
variance
take in front of the
process.
zoning commission to approve it, that they can put that in as a variance to ask for that.
Correct.
It is the zoning commission and not the board of adjustment that looks.
The Board of Adjustment would actually, the Board of Adjustment is here, who would hear the variance request.
They're a quasi judicial board. They're the final decision makers on a variance request. However, if we're going to put in the ordinance that they are allowed to ask for a variance for, specific, for the easements, then that wording would have to go back in front of the zoning commission and then be brought to you, and that would be added as an amendment to our ordinance.
Okay.
Kind of like what we're doing now. And I just want to clarify with Max isn't necessarily just caused by what changes are in front of you. Mac has some easement issues coming off of S23 that obviously there's no documentation. Miranda and I spent an hour and a half looking for stuff in our office yesterday for him because it's just been brought to the two of our attention that he was having issues. And so there may be a recorded document somewhere, but that's his first hurdle, and that isn't anything right now to do with the changes, so.
Those changes, as I recall, when you showed that to me yesterday, they really are private property issues that Matt needs to deal with aside from what we're dealing with here.
Yeah, and it sounds like him and Darren
And
are
so
gonna go to the
issues as far
recorder.
as adding, the address the situation he had, as you showed me, really is a private matter between him and the other property owners until they.
Unless they can come up with a recorded document on that, yeah. So, I mean, he potentially has an option for that part, but then it's just to figure out, does he have, then we would have to address the 150-foot of road frontage off of a primary or secondary road. And again, the Board of Adjustment can make variances, can address variance requests. However, when we have an ordinance in front of them and it's their duty to uphold that ordinance, at what point do they kind of get bombarded with all of the requests for variances and go, okay, I don't, you know, so, and I know each is a case-by-case basis, and they are very diligent in their research and homework on those and do a really good job. No doubt they couldn't do that part of it, but it does add extra to them, like, okay, we have an ordinance, but then, so, those would all be looked at as, I think, case-by-case.
And just to clarify, the variance would be for existing lots of record that do not have access. It wouldn't be allowed in future development. It would be for cases of landlocked parcels that currently exist needing access.
You mean for them to apply for a variance? Yes.
Correct, for the easement.
Yeah.
Because one of the safety issues that drove this change was the building on easements.
Mhm.
So we wouldn't want to perpetuate that by allowing them.
Okay. All right.
So under Matt's situation right now, if we just adopt this exactly the way we adopted it yesterday, does he have the ability to go, to file a variance the way it's written right now?
No, because I don't have the land in my name. I have to do the split, and what she's saying is the new split wouldn't be allowed because it'd be landlocked.
Oh. Okay. Yeah.
So the fact that it's not in his name is an issue?
I'm not familiar with his specific case,
Okay.
so I can't speak to that.
I got you. That's asking you to do a lot, isn't it?
I
Okay.
got you. I got you.
Okay. Well, that's clear.
That's
Okay.
My recommendation to you is that you proceed forward, either vote up or down on what you voted on yesterday. This isn't a time to make changes. It's either yes or it's no. If you're gonna make changes, then you're gonna restart the whole process again. And that's kind of what we talked about yesterday, in my opinion. Okay? If you wanna make changes after this, you can do that. But that's another day. And that's a whole nother process that you're gonna restart by going to the zoning board. Zoning board's gonna hear what the proposed changes are. They will make their recommendation to you, and then you will take that, just like you are today. Because all these have been put through the zoning board prior to today, okay? In my opinion, they have a right to hear what changes that you're proposing, if you're gonna propose any down the road. Okay? Work through the process. Just continue to trust the process, it's working.
Thank you, Doug.
I'm prepared to vote on the process, the ordinances before us as we voted yesterday. I think we need to keep the process going as the county attorney suggested, and then if we are going to deal with changes, we need to deal with those after we've adopted these changes to the ordinances. So I think what I'm saying, Darren, is I'm concurring with you that unless it's something that is just totally overriding and affects everybody, I think this needs to keep moving forward at this moment from a product. That's my viewpoint.
Okay.
That this needs to keep moving forward at this moment.
Yeah. Any other comments?
Yeah, I know, back last year, maybe it was, yeah, it was last year, when we kept tabling different, zoning hearings that were coming before us, and we kept causing more and more publications, and they're not cheap. Plus the timeline, having people come back again and again. So I understand the process, and we need to keep going forward. I understand that. But I also understand in protecting the one person and their property rights and able to do what they want to do when it doesn't cause harm to others. I'm really torn with that protection. And I understand, you know, setting the bar high, and the situation happens to be very unique in its different details of it. But just taking out the easement is going to protect us from subdivisions being built that are small and that go off of our major roads, county roads, and the gravel roads. You're having driveway after driveway. So I understand the whole process. I want to protect the one, and taking out that verbiage allows at least one citizen in Warren County not to do what they want to do with their land at this moment. And,
No, I think that it allows everybody to do what they want to do with their land at this given moment if we do this. That's the thing, like, I don't think we can, apply, you know, for one, if we're making decisions on one situation to try to accommodate somebody, I mean, I think I'm trying to be empathetic and understand what you're saying. But I think that is the mistake that has been made in the past, because if Matt gets to do it, then Jenny gets to do it, and then everybody gets to do it, and then all of a sudden we're back in the same situation that we were when we started this process.
yeah.
In fact, Matt's situation is a direct result of what you just outlined right there.
Right.
He wouldn't be in the situation today had they followed their own ordinances
It's
back
so
in
true.
time.
So
Because I went back through and sat down with the zoning folks, and they started to educate me on these, and so unfortunately, he's in a difficult situation because of past,
Mistakes.
yes.
You're exactly right.
I mean, I'm not saying it was a handshake agreement in your situation, but if we know from our history, there's just been a lot of, hey, you can drive across my property and we're neighbors and we're good. And that works for those people 40 years ago. But now the property's gonna transfer and there's no real, valid entrance into that property if somebody really wanted to go take a look legally at any documentation or any, you know, these things have to be filed with the county. And they haven't been. People are just, you know, and then that comes back to us. I mean, we're kind of accountable for making these decisions and it creates problems down the road, as we've all seen in all our zoning meetings the last couple of years. I mean, it's a result of policy and ordinances and adherence to those and enforcement of those at some point. I just think that any entity, whether it's a city or a county or a state, they're all adopting zoning standards and zoning ordinances and enforcing them for planned growth. I mean, this is not a new concept at all. So anyway, I appreciate what you're saying. I would say in Mac's situation that I'm gonna help Mac figure this out. We're gonna work through it, and I think over the next 6 months, you know, we'll adopt things as they make sense for the mass. If it doesn't make sense for the masses, and we're trying to do it individually and make this a perfect scenario for everybody, I think that's a bridge too long.
Well, and really, one of the conversations I had with some folks yesterday, it forced me to figure out why are we doing what we're doing. And I wanted to make sure I understood what is the overall policy direction that we're doing with these things. And I was reminded after talking with some other folks that, Mark, this has gone through 5 additional special meetings of the zoning commission, plus you've had joint meetings otherwise. these issues have all come up, and it's very intentional for some of these things that we're trying to deal with. And one of the key components for me, I come from an ag background, I come from a farm background. I appreciate the fact that we have rural Iowa, and Warren County definitely has rural Iowa as part of its makeup. And so because of that, I feel somewhat that we need to, as officials here, protect rural Iowa. And these ordinances, as they are currently presented to us, are very much in that spirit of doing the balance between what I will call more urban and rural Iowa, and making sure that the rural side of things is protected as much as the urban side of it. And with what we're trying to do here, we're really protecting rural Iowa with part of what we're doing. It's that careful balance with different things that we're doing here. And because we're really, I think, intentionally trying to say we don't want to have subdivisions out in the middle of the countryside next to, a farm family that's trying to raise production animals. That doesn't make a lot of sense. And yet, okay, if people are going to go to rural Iowa, they need to understand that rural Iowa doesn't have everything that urban Iowa has, and it's not going to have everything that urban Iowa is going to have. So that's the balance that we're trying to do here. And as I see us going through this, I think that this is a good balance between those things. And unfortunately, the easement question has been a detriment. I think as you look back in the past, it has created many of the unfortunate circumstances that we're maybe confronted with, where variances are made all over the place. And it's because of that policy that we're where we are today. And I think as we move forward with the growth of the county, I want to protect rural Iowa, rural Warren County, as much as I want to help grow urban Warren County. And so I think we're on the right path. I'm comfortable. I think there are ways to deal with the Jennies and the Matts. I think there are ways to deal with it. It may not be, it may cost them a little bit because they're going to have to go through some hoops to get to where they want to go. But I think that there are options there for them to solve their problems.
Anything else? I mean, I think this has been a good opportunity to find out where we stand.
I really appreciate your comments. Thank you.
Okay, so with that, I'd like to make a motion to adopt the Warren County ordinances revisions to bring them up to date with our 2002 comprehensive plan.
I'll second
Or,
that.
I'm not quite finished because I'm reading this exactly the way I read it yesterday, which wasn't great. So my motion is to adopt these ordinances as written in the documentation that's in our packet, and that refers to Title 5 Property and Land Use, Chapter 46 Subdivision Regulations, and the Warren County zoning ordinance revisions packets or documents that were in our packet. That's my motion.
Second.
Okay, we have a motion and a second. Roll call, please.
McIntyre,
Aye.
Snow,
Aye.
Heater,
Aye.
We'll still have another opportunity tomorrow.
We have another public meeting tomorrow morning at 9 a.m. and we'll go through this exact same procedure.
And we'll probably have a lot more conversation between today and tomorrow with people who share things with us.
Exactly. I want to thank the people from the public that have spoken. Thank our Board of Supervisors for their comments and diligence around this. These are tough decisions. And I believe we're headed in the right direction. And with that, I'll make a motion to adjourn this meeting.
Second.
Roll call, please.
McIntyre,
Aye.
Snow,
Aye.
Heater.
Aye. Thank you very much. Matt, do you have a minute?